Hello, hello. Welcome back to Office Hours Politics Edition. I am your host, Ziana, and today's episode is one I've been waiting to record for a very long time because it's where law, morality, and empire collide. Today we're talking about the International Criminal Court, or the ICC, and the uncomfortable truth behind its promise of global justice. Because here's the thing, ICC was created to hold the powerful accountable, but in practice, it often protects them. It claims to stand above nations, but it acts like an instrument of the most powerful ones. So the question is, who does international law actually serve? When we say law beyond the nation, we imagine a system that transcends borders, that ensures no one, not even the heads of state, are above justice. But in reality, the ICC has become a symbol of selective justice, harsh towards the global south, silent towards the west. From Africa to Palestine, from Iraq to Ukraine, the ICC's record tells a story not of neutrality, but of hierarchy. So, in this episode, we will unpack the origins of the ICC, how international law was built on colonial legacies, why the ICC prosecutes African leaders but spares Western ones, the politics behind human rights language, and whether law can ever exist beyond the power that created it. Let's get into it. Law beyond the nation, the hypocrisy of the ICC. Let's go back to where it all started. The International Criminal Court was established in 2002 under Roman statute. It was supposed to be a revolutionary idea. Permanent court to try individuals, not states, for genocide, war crimes, and crimes against humanity. For the first time, the world said, no matter who you are, justice will find you. It sounds noble. It sounds moral. It sounded like progress after the horrors of Rwanda, Bosnia, and the Holocaust. But here's the problem. The ICC was never as global as it claimed to be. The United States, Russia, and China, three of the world's most powerful states, refused to join. Why? Because they knew that real global justice might one day turn its gaze towards them. So from the beginning, the ICC's jurisdiction was limited. It could only prosecute crimes committed on the territory of member states or referred to by the United Nations Security Council. And guess who controls the Security Council? 5 permanent members, including the United States, the UK, and France. So already this so-called independent court was born with strings attached. Legal scholars call this the paradox of international law. It claims universality, but it depends on state consent, especially the consent of the powerful. From day one, the law beyond the nation was a myth. It was a law that served nations, or more specifically, certain nations. To understand the ICC, you have to understand the foundation it stands on: international law itself. International law didn't emerge in a vacuum, it was born out of colonialism. Many thinkers argue that the very concept of universal law was created to justify empire. European powers used law to define who was civilized and who wasn't. Colonial conquest was framed not as theft, but as legal order. This can be called as the dynamic of difference, the idea that the international law constructs a moral hierarchy between the West and the rest. The West brings order. The rest needs disciplining. Fast forward to today, the same logic still shapes how the ICC operates. Look at who gets prosecuted: African leaders, Middle Eastern militants, Balkan generals. And look who doesn't: American presidents, Israeli generals, European heads of state. The ICC doesn't exist beyond the nation. It exists beyond some nations. It's law without borders, but not without bias. And here's the hypocrisy. When Western nations wage war, it's called intervention. And when the global South resists it, it's called an atrocity. Moving on to selective justice. For nearly 2 decades, every single ICC case involved an African country. Uganda, Sudan, Kenya, the Democratic Republic of Congo, the Central African Republic. The irony, most of these cases were referred by African governments themselves under pressure from the West to target political rivals. Sudan's Omar al-Bashir was faced with war crime charges, while George W. Bush, Tony Blair, and others responsible for the Iraq invasion faced none. African leaders soon started calling out this bias. The African Union accused the ICC of being a neo-colonial court. Even Nelson Mandela's successors warned that the ICC had turned into a political weapon. And they were not wrong. When Libya collapsed after the NATO intervention, there were calls to investigate Western war crimes. The ICC looked the other way. When the US tortured detainees in Afghanistan, the ICC prosecutor initially announced an investigation until the US government revoked her visa and threatened sanctions. The message was clear. Some nations are untouchable. Law is supposed to be the great equalizer. But in international politics, law often reinforces inequality. It punishes the weak to absolve the strong. Nowhere is the hypocrisy clearer than in Palestine. Decades, Palestinians have appealed to international law, documenting war crimes, settlement expansions, and the use of collective punishment. When the ICC finally opened an investigation into Israel in 2021, Western governments condemned it. The US called it unfair. The EU called it counterproductive. But when Russia invaded Ukraine in 2022, the same government celebrated the ICC's involvement. It fast-tracked funding, evidence, and political support. Now, I'm not saying Ukraine doesn't deserve justice. It absolutely does. But the double standard reveals something deeper. International law responds not to suffering, but to a political alignment. The ICC's empathy is selective. It sees European pain very clear, and it blurs the suffering of the colonized. International law promises protection, but it only delivers when it's convenient to power. The result? The ICC becomes an instrument of global legitimacy, legitimizing Western outrage while delegitimizing non-Western resistance. But here's where things get uncomfortable. Because human rights, the language of international law, isn't neutral either. Human rights are framed as universal, but they're often selective. They justify intervention, sanctions, and regime change. Remember the quote-unquote invasion of Iraq? It was framed as a humanitarian mission to liberate the Iraqi people. But no one was held accountable for the hundreds of thousands of civilians killed. Human rights becomes a rhetorical weapon, a way to moralize foreign policy. Instead of addressing inequality, they create a moral spectacle of good versus evil, civilized versus barbaric, and that's exactly how the ICC functions. It gave us villains, not systems. It personalizes guilt, not power, and it makes justice visible, but extremely shallow. So, can law truly exist beyond the nation? Power. Realistically, not yet, because law without enforcement is symbolism, and enforcement depends on power. The ICC cannot compel the United States or Israel or Russia to comply. It can only act when it's allowed to. It depends on the very nation. It depends on the very nations it's supposed to constrain. But that doesn't mean international law is meaningless. It gives language to resistance. It creates archives of truth. It allows activists, victims, and journalists to name injustice, even when justice isn't served. The problem isn't law itself, it's the illusion that law can be neutral in an unequal world. To move forward, international law must decolonize, not just in rhetoric, but in structure. It means redistributing power, reforming the UN Security Council, democratizing global institutions, and centering global South voices. Until then, this quote, law beyond the nation will remain what it has always been, law beneath empire. So what do we take away from all of this? The ICC isn't a failure of law. It's a reflection of global power. It shows us that justice isn't blind. It sees borders. It sees wealth. It sees alliances. So when we say no one is above the law, we have to ask whose law? International justice was supposed to end impunity. Instead, it often reproduces it. But awareness matters. Every critique, every investigation, every challenge to selective justice matters because it keeps the conversation alive. Maybe one day, law beyond the nation will truly mean justice without empire. Until then, it's up to us, scholars, citizens, students, to keep asking uncomfortable questions because silence is what keeps hypocrisy alive. Thank you guys so much for tuning in this week. Until next time, stay curious, stay critical, and remember, justice without equality is just a performance. Bye.